Question is that the bill be now read a second time. Mr. Chris de Souza.
Mr. Speaker, sir, today we are debating the necessity and proposed refinements to the CLTPA. The Criminal Law Temporary Provisions Act is a necessary tool for Singapore to dismantle criminal syndicates. Secret societies continue to make up the majority of the detainee population. In 2016, 91 of the 109 detainees were detained because of secret society gang activity. This is not surprising, as strong loyalties and a pervasive network easily intimidate witnesses, making it impossible for an open court trial. Projecting into the next 5 years, the CLTPA still remains a necessary tool for law enforcers. This is because there is still a need to be able to carry out actions even though witnesses are afraid to step forward and even when it is impossible to procure evidence without undermining the territorial integrity of another jurisdiction. While international collaboration and technology such as forensic and video recording evidence may allow us to do what was previously not possible in terms of evidence gathering, technology has a flip side. It also enables intimidation of witnesses and made it easier for crimes to take on a syndicated nature, multiplying the propensity of harm and intimidation like a sinister phalanx formation. This is not a figment of imagination out of a comic strip. This is real. So we need an arsenal of laws to deploy to deter and overcome the morphing nature of criminal syndicates. I listened to what the Minister said quite carefully, and I agree with the Minister's views that the fear of witnesses coming to court does prejudice justice, does prejudice law enforcement and the rule of law. I agree with this because of my own experience. When I started off in the legal service at the Attorney General's chambers, when you know the suspect is very likely to have done it, and the only witness to corroborate fears for his life or his family life, then he doesn't come to court. Drugs under the Misuse of Drugs Act is a good example. The trafficker or the suspected trafficker may have drugs, but who is he trying to traffic to? And if the witness who is meant to have received the drugs so as to prove the trafficking case or the charge says, no, I don't want to come, I fear for my life and my safety, then it does prejudice the procedures. Similarly, for the Prevention of Human Trafficking Act, a person could have trafficked a woman, abused her, and she is very likely to have been someone from overseas and therefore fears for the life of her family overseas. What do we do with someone who all the intelligence shows very likely committed the crime, but there is no witness to corroborate that? Do we just let him go without the facility of a CLTPA detention? Also, when I sat as a junior judge and there wasn't a witness to corroborate the charge, then the burden of proof is not met, notwithstanding a lot of evidence against the person who is being charged. And even in private practice now, having a good witness is a real advantage to the case. So, from my perspective, I agree with the Minister that where you have situations where all the other facts and all the other evidence point to the conclusion that the person very likely did it, and you don't have somebody who's willing to come forward because of fear of his life or a legitimate fear of his family's life, we need something like the CLTPA to plug that gap. Of course, we need safeguards within the CLTPA itself. And since the last time the CLTPA was renewed, there has been a successful appeal on detention under the CLTPA. This case impacts our debate on the bill for two reasons. One, it sheds light on the implication of Clause 3 that says the minister's decision is final. And two, its observations birthed the new fourth schedule specifying the serious criminal activities as legitimate grounds for a detention under the Act. Newspapers have reported some concern raised over Clause 3 of the bill. However, in my view, those concerns can be ameliorated as the clause does not change the law. The bill supplement clearly says it is to clarify the law. What was reviewable in the past continues to be reviewable. Clause 8 puts in the new fourth schedule, which specifies the scope of criminal activities, the powers of detention and supervision orders may be exercised for. This promotes the rule of law as it delineates the parameters of the power clearly. It is necessarily wide so as not to remove the efficaciousness of the Act, but allows for a more concrete understanding of the scope of power and what is sufficiently serious, an issue examined by the Court of Appeal in the Tan Sit Eng case. One thing worth noting about the fourth schedule is the reference to Section 48, subsection 1 of the Organized Crimes Act. It recognizes the problems with syndicates and also provides the possibility for international activities with local links to be tackled, such as that of match fixing in the situation of Tan Sit Eng. Nevertheless, it is important that this act not be invoked merely because a criminal activity is specified in the list. For the interests of justice, the act should still only be resorted to, not only in the most serious of those activities, but when an open court trial is impracticable. A trial by the court must still remain and continue to be the primary mechanism of law enforcement and judicial adjudication. This bill also makes some changes to the police supervisory regime. One of them is regarding restrictions able to be imposed on a person under police investigation or supervision. Currently, Section 33, subsection 1 allows for the possibility to impose all or any of the restrictions, and subsection 2 provides for the minister being able to vary, cancel, or add restrictions specified under Section 33(1). Clause 4 purports to make the regime more flexible by moving the restrictions placed on those on police supervision from the main act to subsidiary legislation. This seems to remove boundaries and categories on the kind of restrictions being imposed, as the previous structure also allows for some form of flexibility. Would the Minister of Home Affairs kindly elaborate on the rationale behind this change? Besides detention without trial and supervision orders, this act criminalizes strikes for employees of essential services, something which drew public attention in 2012. Although the repercussions of that strike then may not have been as deeply felt, a protracted strike on essential services can be quite severe. Therefore, notwithstanding this bill, it is important that channels of dialogue for amicable settlements of disputes between providers of essential services and their employees remain open and effective. As this bill continues to provide a necessary tool to maintain Singapore's public safety, peace, and good order, and the very fact that we need to deploy muscular laws to deter criminal syndicate activity on our shores, and based on my own experience as a legal practitioner in the government and in the private sector, I support this bill.